Okay, this is appeal number 20 on today's calendar, the people of the state of New York versus Leslie Old. Counsel?
Thank you. Good afternoon, Your Honor. May it please the court. My name is Michael Deal at the Legal Aid Bureau of Buffalo, representing defendant appellant Leslie Olds. Before we begin, I would like to reserve 2 minutes for rebuttal, please. Thank you.
Of course, of course.
I'm sorry, Judge.
You may proceed.
Thank you. I would just like to start with a comment on the preservation issue raised by the people and decided in the lower court, the intermediate appellate court. And that is, as set forth in our pleadings, that I believe this situation falls squarely within the prescriptions of CPL 470.05 sub 2. Recall, or we should note from the outset, this was a normal sentencing argument in every respect until, of course, the sentence was pronounced. What I mean by that is this is the type of appearance that, at least until our pause here last year, occurred probably every working day in the state of New York, meaning...
Judge Stein?
Yeah, here, though, I mean, you had a plea agreement, right? And the plea agreement had no sentencing promises, right? And so my question with regard to preservation, I have a number of questions, but with regard to preservation is how did your client put the court on notice that it could not, as a matter of constitutional law, impose a term of incarceration? As I read the transcript, the attorney was arguing he shouldn't get a sentence of incarceration, and here are all the reasons, and then goes on to say, but if you're going to give him a term of incarceration, he shouldn't get the max, and so on and so forth. So it sounded to me more like a fairness argument than anything that would put the court on notice that, you know, we're talking about a potentially vindictive sentence here in a matter of due process. So that's my question about preservation.
Sure, and I'll clarify, I was that attorney. So
okay. I'm sorry, yeah.
I was not the original attorney at trial in the town of Lewiston, but I came on board pre-sentence and have stayed on for years. But to answer your question, Justice Stein, one, it presupposes the necessity of putting the court on notice that that there's a potential constitutional violation for a sentence it's going to impose. And I don't agree that that's a necessary requirement. But having said that, it's clear that...
Judge, can I jump in for 1 second?
Judge Fahey?
Yeah, Mr. Deal, just on that first point you raised, I just wanted to go to that before you got off of it. Isn't that why you would normally make a motion to withdraw the plea to preserve that argument then?
The cases, Judge Fahey, that were relied upon in the intermediate appellate court and by the people relative to motions to vacate pleas or withdraw pleas.
You're talking about when you were a county court?
Yes.
Right, okay, go ahead.
I'm sorry, when I was at county court.
It's fine.
Those cases were all depending or all related to situations where there was a committed to sentence, and that based on some failure of the defendant to follow a condition that the court imposed at the time of taking the plea, that the court at the time of sentencing then decided it could not maintain its previous commitment and needed to deviate from that commitment. And I believe that the reason for requiring a motion to vacate at that time is because there's in effect a contractual relationship specific rather to the issue of sentencing, and that to properly litigate whether or not deviation would be appropriate, you need to put that before the sentencing court to litigate it. And therefore, if you just go forward with sentencing in that situation and the court deviates, and then you challenge later on appeal, you haven't properly preserved the issue. Here, and to kind of fold back into Justice Stein's question, yes, there was a plea agreement in the sense that there was decision made to file the special or prosecutor's information and that Mr. Olds would plead guilty. But there was no discussion as to sentence at all. It's the sentence was left open, if you will.
But I don't know if that works in your client's favor. To me, that suggests that that it was, you know, he was willing to take that chance.
Well, he was willing to take that chance, but for the imposition of an illegal sentence. And I don't believe that it was, I was required to put the sentencing court on notice formally by filing a motion that imposition of the maximum sentence for that charge, which was 1 year of incarceration, you know, was unconstitutional. And I'll go back to, you said you read the transcript, and the very first words that I uttered relative to sentencing in the transcript, which is at page 24 of the appendix, was I believe the court should not impose a term of incarceration from the outset, and I'll tell you why. And then, as you noticed, I went through the various arguments of why. But let's skip ahead to page 27 of the appendix, where I mentioned specifically, nothing has occurred of any significance from the time he was put on probation before to now that would warrant a deviation from a probationary sentence. I then, within a few lines, referenced specifically imposition of a maximum sentence. So I without having said, I'm warning you, Justice, you know, trial justice, that you're about to, you know, consideration of a incarceral sentence here is a constitutional violation. I made the argument without referencing those several words. I don't think it was necessary to file a motion to vacate that plea, to formally raise that argument for the reasons I said before. But I made the argument without couching it in constitutional terms to begin with. Having said that, I think it falls within the
Chief Judge, may I ask another question?
Judge Stein?
Assuming that we were to find your argument preserved, on what basis should we find that there was a presumption of vindictiveness here and or actual vindictiveness here?
Sure. Well, this is a unique fact pattern for this issue. I haven't found any case that has this type of fact pattern where there was a trial, a conviction after trial, rather, an imposition of probationary sentence, non-incarceral, which is overturned on appeal, and then a plea where the sentence is the maximum term allowed by law without any affirmative declaration on the record as to why. So I think that fact pattern alone raises the issue for sure, in the sense that after a trial where a victim testified, a minor victim, by the way, testified, that the probation or that the sentencing court at that time determined probation was an appropriate sentence.
So, Chief, if I may.
Yes, Judge Feynman.
So you're asking us to compare what transpired at the Lewiston Town Court and, you know, what transpired at the subsequent, you know, when it was transferred to a different town court. But how do we compare these two sentences? My concern has to do with the record, actually before us. How do we compare these two sentences if we don't even have the record of the first sentence? You know, how many years probation did he get? Now, I know there are secondary sources such as the pre-sentence report, and there are various statements in your briefs, but we don't actually have a record as to what transpired the first time around. And if we assume that the first sentence was 6 years probation, do we compare that to the term of 1 year incarceration? And does it matter if it was 10 years probation or something, how do you decide which is worse, 10 years probation versus 1 year's incarceration? My experience, both as a defense lawyer and as a criminal court judge, is a lot of people would rather take the so-called bullet of 1 year, especially if you're going to be eligible for release after 60 days, unconditional release, than go through an extended probation sentence, where they're going to be constantly dragged in for a violation of probation or and subject to resentencing. So I know I've thrown a lot of things at you. Let's see if you can sort it out.
Well, I believe the gist of what you're saying, Justice Feynman, is that there should be there whether or not there is an equivalency between any term of probation and an incarceral sentence, and if so, can you parse out whether it depends a longer term of probation or shorter term or et cetera. And I don't disagree with you. I'm sure I know there's certainly anecdotal evidence of criminal defendants who have chosen to do their time and not go on probation. It's not a rule of thumb by any stretch, and I can tell you with surety, Mr. Olds did not want to go to jail. Period.
Thank you, counsel. Thank you, counsel. Counsel?
Thank you, Your Honor. Laura Jordan on behalf of the Niagara County District Attorney's Office. Talking first about the preservation issue. While there was, a lengthy argument by defense counsel prior to the pronouncement of sentence against incarceration, there was no objection made. There was no motion to vacate the judgment of conviction after the sentence was pronounced. As I pointed out in my brief, the case law has been consistent throughout the departments, and this court has declined to review it, that is required. This court has discussed also in some of the cases cited by those department cases, the need for finality in a criminal case.
Judge, may I ask a quick question on that?
Judge Stein.
I just want to clarify your position. Are you saying that either an objection or a motion to vacate would suffice? Or are you saying that you have to have the motion to vacate?
I would say you have to have the motion to vacate, but we didn't have either in this case.
Okay, but that's not what the appellate division cases seem to indicate, right? They seem to indicate, a lot of times they say, well, the defendant neither did this nor that. So if we were to agree with the appellate division rule, it would suffice if either one was done, right?
Yes, Your Honor. But in this case, I submit we didn't have either of those situations.
Thank you.
Judge?
If I may ask?
Yes,
Go ahead.
Judge Rivera.
I'm just going to want to clarify this way you're thinking about preservation. So if his argument is the sentence is illegal because it's vindictive, he's got to make a motion to withdraw saying, Judge, you've just been vindictive. So let me withdraw. I want to move to withdraw the sentence. Is that your position?
Not if the sentence itself would be illegal, but I guess my position is
Why isn't a vindictive sentence? If that's the argument, they may not win on the merits, but that's the argument. Why isn't that an illegal sentence that then doesn't, as I assume you were going to say, is not subject to the rule of preservation?
right. So it's not, I would say it would fall more under the cases that I cited in my brief, in that it's an enhanced sentence based on the fact that he won the appeal the first time, not an illegal sentence, which would fall under the need for preservation.
And Judge,
If we just, let me just,
Yes, Judge Fahey.
if I could just follow up on that, Judge?
sure, go ahead.
Yeah.
Judge Rivera.
Thank you very much. So if we did not agree with you on that and we decided it was an illegal sentence, does that mean there is no longer a preservation issue in the case?
I would think so, yes, Your Honor.
Thank you.
Judge Fahey.
Just taking a step off preservation for a second. The argument here is that it's an enhancement. It's an illegal enhancement, but it's unconstitutional. So what objective facts in the record would you point to that would justify the courts not reimposing probation and imposing a term of incarceration?
So there was information in the PSI about the approximate 6 months that this defendant had been on probation from the time of the first sentence until that case was overturned. And when he was on probation, he did not perform well. He did not engage in the...
What does that mean?
He didn't engage in the treatment that he was supposed to engage in. The probation officer also said that he was very disruptive to the other probationers that she was supervising whenever he would come in. And those were the reasons that the probation department pointed to as to why he would not be.
There were some things that I saw in the record, and I saw things like there were a couple failures to appear, a threatening letter to a judge. He's terminated from his SO treatment for sex offender treatment for refusal to attend. And there were inappropriate remarks to the victim. And I'm not sure if they're part of the record or not. They may have just been in a letter and shouldn't really be applied against this defendant. But were those facts relied upon by the judge in this case?
I guess we have to assume so, Your Honor.
And you say that because it was in the PSR?
It was in the PSI. There was quite a bit of discussion by defense counsel prior to sentencing about the PSI. The trial court indicated that they had read it, even referencing the polygraph, which they said that they were going to ignore. So they did make some reference to some specific parts of the PSI, although they didn't lay out all of those reasons, admittedly on the record at the time the court pronounced sentence.
I see. Okay, thanks.
And I guess going to that.
Can I ask a question, Chief Judge?
Yes, Judge Garcia.
What I'm struggling with, I guess, to get back to some of the other preservation questions and tying into what Judge Fahey just asked is, it seems to me if you have an illegal sentence, you have a plea, a sentence is imposed beyond the term permitted by law. That's one issue, and we can look at that and determine by the plea to the specific penal provision whether it's illegal or not. But in a case like this, in a vindictive sentence, we're really now, as Judge Fahey was exploring, trying to figure out what in the record and what the judge relied on in a case where the specific vindictiveness objection wasn't made. And to me, that's a much different situation in terms of an illegal sentence or a sentence that shouldn't have been imposed than you would have from a straightforward application of the rules as to what term a specific defendant could get for this crime. So it's very hard for me to parse out preservation from what's in the record, because as I read this transcript, there was never an objection made on vindictiveness before or after the sentence was imposed.
Right, and the only point that gets brought up then is at the appellate process. And I mean, it's our position, we're not even at a point of vindictiveness. I mean, the simple fact that it was overturned on appeal and he received a harsher sentence, that alone isn't enough to even trigger the vindictiveness argument. We had a completely different judge and a completely different court looking at the facts differently. We didn't have any motivation, to punish would be my submission. The first court never saw the initial trial. There wasn't a second trial. There wasn't any reason to, sort of quote unquote punish the defendant for making the victim go through it a second time. So I don't even think, I would submit that we don't even reach the point of vindictiveness in this case because of the circumstances under which he was sentenced the second time. If there are no further questions, I would rest on my brief, Your Honors. Thank you.
Thank you, counsel. Mr. Deal?
Thank you. Just to very briefly touch on the last couple of points. Justice Garcia referenced the situation as no objection specific to vindictiveness having been made. Again, our position is that the objection was made under CPL 470.05 sub 2, where an argument was made specifically for non-incarceral and certainly non-maximum sentence, that there was no conduct occurring since the time of the original sentencing. That happens in terms of sentences every single day here. So that's an objection. And as Justice DeFiore mentioned, or rather, I'm sorry, Justice Stein mentioned that the case law relative to enhanced sentencing from the appellate divisions all say objection or motion to vacate. Well, they say one or the other, and I believe this falls clearly under the objection language, the preservation language in the 470.05.
Let me ask a question.
Judge
Yes.
Rivera.
Yes, thank you. Okay. So, counsel, you before said it's an illegal sentence. I asked Ms. Jordan about that. Her position, of course, her office's position, her position is that it's not a legal sentence. And Judge Garcia has already pointed to this also, of course, in the traditional sense. It's just an enhancement. He got time. He got more than what he anticipated. So what is your response to that?
Well, I think it's an illegal sentence because it's vindictive. I think it's clear it's vindictive. And Ms. Jordan said in an answer regarding
Are there cases where we have characterized a vindictive sentence using the term illegal sentence? Because I think as a general understanding, a legal sentence means one not authorized like by the sentencing guidelines or the sentencing statutes. And so I'm just curious if you're aware of any case where we have said that vindictive and illegal are synonymous.
I'm not aware. I do not believe that has been said that specifically. I do know.
Is a vindictive sentence constitutionally permissible?
No, it is not. It is a violation of the due process protections.
Yeah, the problem I think that Judge Feinman's getting at, which I asked your adversary, is we need to find record facts in order to determine this is an illegal sentence. It isn't you pled to X, you got a sentence of Y that's not authorized by the statute. I think that's Judge Feinman's example. Here, in order for us to reach the conclusion you'd like us to that it's an illegal sentence, we need to see what the judge relied upon. And a simple objection that this is vindictive would have, you would think, then prompted an explanation of the judge's reasons for giving what you're terming an enhanced sentence, and we're arguing about that. But that, to me, is the real difference between requiring the objection in this case, so the court has something to look at, rather than, well, that's what we meant, and there's no record. Did he rely on the PSI? Did he rely? We don't know. Then it is to say, okay, it's an illegal sentence, and all we have to do is look at the penal law and look at the sentencing provisions.
I'm saying it's a vindictive sentence. I'm saying generally that vindictive sentences are illegal. And the issue here is the way you've phrased it is the issue that runs through the whole problem to begin with, which is the judge did not say what he relied upon, period. And I get your point, Justice Garcia. Had there been an objection specifically grounded on vindictiveness, that may have allowed the judge to respond in kind. The facts of the matter would have been that the very sentencing argument I made, which is, by the way, I made the argument twice. It's basically the same argument that I made for a copy of the pre-sentence report and an adjournment of sentencing. But the argument reaches every single factual issue that he did not address as a reason for his sentence.
Do you have one more question? What, besides the fact that the sentence imposed an incarceration, a period of incarceration, and the first sentence did not, what do you point to in the record to show that there was any vindictiveness here?
What I point to in the record is, one, the denial of my request for an adjournment, the denial of my request for a copy to be made of the pre-sentence report, Those were just dismissed out of hand in the face of the very factual bases that I made to the judge in terms of sentencing. Additionally, the circumstances itself that help the presumption arise in the first place, where you have a clearly non-incarceral sentence of probation and a SORA determination versus the maximum sentence imposed without any explanation by the judge as to why he's imposing the sentence. And that's the true failure here, is that this judge did not say why. Not only why should Mr. Olds have gone to jail, he didn't say why the maximum sentence. He didn't say anything as simple as, I adopt everything that you said, Mr. Deal, regarding the pre-sentence report. I disagree with you. Here's my sentence. He didn't say that. All he said was, I have to be the heavy. I have no idea what that means in that context, other than I'm going to punish you. And you're in front of me right now. And that's the way I took that phrase. And that's why I think that there's evidence of vindictiveness, because we're looking for things in the record to show he wasn't vindictive. And the problem is he didn't tell us what he relied on at all. Nothing.
Thank you, counsel.
We can't
Thank you, counsel.
assume for him. Thank you.